The Reserve Bank of India has informed the top court that borrowers opting for resolution of COVID-related stressed loans shall not be required to submit any specific plans. RBI had announced a resolution framework to help the entities facing financial stress on account of disruption in normal business activity on account of coronavirus.
The Reserve Bank has informed the Supreme Court that borrowers opting for resolution of COVID-related stressed loans are not required to submit any specific plans. In frequently asked questions on resolution framework for COVID-19 related stress, the RBI has said that borrowers can invoke the resolution framework by merely submitting a request to the lending institutions. Earlier, Central Bank announced a resolution framework to mitigate the financial stress faced by entities due to disruption in business activities on account of the coronavirus pandemic. In this background, RBI has told top court that specific contours of resolution plan to be implemented may be decided by the lending institution in consultation with the borrower. Senior advocate V.V. Giri appeared for the Reserve Bank of India, argued that the discretion to frame a resolution plan should be with the bank and not the borrower. As per the frequently asked questions, restructuring in respect of projects under implementation involving deferment of DCCO or date of commencement of commercial operations are excluded from the scope of resolution framework. The banking regulator emphasized that the extant regulations and other relevant instructions as applicable to specific category of lending institutions already permit revisions of the DCCO and consequential shift in repayment schedule without being treated as restructuring, subject to a maximum of 4 years in the case of infrastructure projects and a maximum of 2 years in the case of non-infrastructure projects, including commercial real estate exposures. Bureau Report.
The Supreme Court has agreed to examine whether or not it can go into the constitutional validity of the 1975 national emergency proclaimed by then Prime Minister Indira Gandhi.
Supreme Court has agreed to examine whether probing constitutionality of declaration of 1975 emergency is feasible after 45 years. A Supreme Court bench of Justices Sanjay Kishan Kaul, Dinesh Maheshwari and Rishikesh Roy issued notice to the central government stating that it will hear the petitioner on the limited aspect of whether the validity of emergency proclamation can be probed by the court after passage of such a long time. The order was passed after hearing senior advocate Harish Salve appearing for the petitioner argued that the court is empowered to examine the validity of the proclamation of emergency. War crimes are still heard post-World War. People are raising issues of Holocaust now. National emergency was a fraud on the Constitution. We must have this decided by the court. I feel very strongly for this. This is not a matter of political debate. It didn't happen to the prisoners during emergency, Harish Salve said. The court was initially not inclined to entertain the matter, but subsequently agreed to examine the aspect of whether the validity of the proclamation can be gone into after passage of more than 45 years. The plea filed by 94-year-old Vera Serene seeks a declaration that the presidential notification proclaiming 1975 national emergency was unconstitutional. Serene has also prayed for damages to the tune of rupees 25 crores. Serene has claimed that she, along with her husband, were compelled to leave the country for fear of being thrown into jail in pursuance of unjustifiable and arbitrary detention orders issued against her husband. In a petition she had submitted that her late husband was framed under Conservation of Foreign Exchange and Prevention of Smuggling Activities Act 1974, among other things. Their immovable property came to be seized. The movable property consisting of artifacts, gems, carpets, paintings, dust, statues, ivory worth crores of rupees were also seized, and there has been no restitution of the same till date, the petitioner has claimed. After the husband of the petitioner died in 2000, the petitioner had to single-handedly face all legal proceedings initiated against her husband during the emergency period it was submitted. Further, the High Court had held in December 2014 that the proceedings under SAFEMA were initiated bereft of any jurisdiction and therefore a nullity. Bureau Report.
For more updates, we are joined by Advocate Adarsh Kumar. Adarsh, tell us about the court proceedings in this case.
Supreme Court has said that we have heard survey on the subject matter with some trepidation, more so arising due to passing of time. It is his submission that the wrongs of history must be right. We would be disinclined to open all such aspects as there might have been wrongs done the person, but with the passage of almost 45 years, it would not be appropriate to reopen such issues. We would, however, be not disinclined to see whether a simpliciter declaration, something which is feasible or desirable after the passage of time of the issues. Respected to that, accept learned senior counsel to give better throw to the matter to respected petition. Leave granted to amend the petition by 18th of December and let's notice the issues. Yes.
Thank you for joining us. The Supreme Court has adjourned Ansal brothers' plea to deseal the Upar fire tragedy. The next hearing is on July. The bench declined urgent hearing on the plea seeking desealing of the ill-fated Upar theatre, observing that there is no urgency in the matter.
The Supreme Court has adjourned till July 2021 the plea filed seeking the release of Upar Theatre, which has been sealed by the CBI, where 59 people had died and over 100 received injuries during the screening of Bollywood film Border on 13 June 1997. The CBI, which has probed the prosecuted, the two owners, Sushil Anshal and Gopal Ansal, in the case, has been opposing the desealing and release of the cinema hall. A Supreme Court division bench comprising then Chief Justice J.S. Kehar and Justice D.Y. Chandrachud had in 2017 declined urgent hearing on a plea seeking release of the ill-fated Upar Theatre, observing that there is no urgency in the matter. The agency and the Association of Victim Upar Tragedy, led by Neelam Krishnamurthy, had alleged that the plea seeking of the trial of the IPS officer Amod Kant, who in the capacity of DCB had allegedly allowed retention of 37 extra seats in the theatre in 1979 in violation of the Cinematography Act, is still pending. The release of the cinema hall could have led to the loss of crucial evidence that extra seat had resulted in closure of gangway, leading to the death of many. In its final order on 25 August 2015, the Supreme Court has sentenced the Ansal brother to a 2-year jail term if they fail to pay the families of the victim rupees 30 crore each within 3 months. The apex court had later directed Gopal Ansal to serve 1 year in jail, and his elder brother Sushil Anshal was relieved from the incarceration with the prison term that he had already undergone. The Upar fire was one of the worst fire tragedies in memory. On Friday, 13 June 1997, 59 people were trapped inside and died of asphyxiation, while 103 were seriously injured in the resulting stampede in the Cameron Green Park, New Delhi. Bureau Report.
The central government sought time to submit its report on how the new ordinance against air pollution has worked so far in a few days. The Supreme Court is expected to hear this matter on Thursday after the report is brought on record. Senior advocate Vikas Singh sought the Supreme Court's permission for oral mentioning in the stubble burning case. The 3-judge bench headed by Chief Justice of India, Justice S.A. Bobde, Justices A.S. Bopanna and V. Ramasubramaniam heard the matter. The Chief Justice of India replied that it has not to be done through emails. Vikas Singh informed the court that the government has constituted a committee with 4 members, but the committee has done nothing and the matter is concerning public health issue and the affidavit has not been filed yet. Senior advocate Aishwarya Bhati, who appeared for the central government, told the apex court that the affidavit will be placed in a day before the bench. Bhati said the situation regarding air pollution is better since December 3 and requested the bench to grant the government 2 days to file the affidavit. There is no provision under the Constitution or the Representation of People Act prescribing that elections to Rajya Sabha seats which fell vacant on separate dates should be held through a single by-election. External Affairs Minister Dr. S. Jaishankar told the Supreme Court. In an affidavit filed before the top court, Dr. Jaishankar submitted that there was no violation of any law in his election to Rajya Sabha from Gujarat. The affidavit was filed in response to a petition by Congress leader Gaurav Pandya assailing Dr. Jaishankar's election, claiming that the Election Commission issued two separate notifications for holding by-polls for casual and regular vacancies in Rajya Sabha, and the same was in violation of the law. The Gujarat High Court in September 2019 dismissed Pandya's plea. Pandya, in his appeal before the Supreme Court, stated that the High Court erred in the law by ruling that his election petition was to be dismissed on the ground that he was neither a voter nor a candidate in the election in question. The plea filed through advocate on record, Krishti Jain, said that in 2017, BJP leaders Amit Shah and Smriti Irani were elected to the Rajya Sabha. Later in 2019, they got elected to the Lok Sabha and consequently, 2 seats fell vacant. The Uttar Pradesh government has moved the Supreme Court challenging a September 1 order of the Allahabad High Court quashing Dr. Kafil Khan's detention under the National Security Act. The appeal, which was filed on October 26, is likely to come up for hearing on December 17. A division bench of Justice Govind Mahathur and Justice Soumitra Dayal Singh of the Allahabad High Court had allowed the writ petition filed on behalf of Dr. Khan by his mother Nuzhat Parveen and quashed Khan's detention. Dr. Khan was lodged in Mathura jail for an allegedly provocative speech at the Aligarh Muslim University in the backdrop of protest against the Citizenship Amendment Act. Interestingly, the High Court had noted in its judgment that contrary to claims by the state, Khan's speech called for violence and hatred. It actually called for national integrity and unity. While passing its order, the Supreme Court had also observed that matters concerning personal liberty have always been prioritized by the apex court. In light of the fact that this matter involved Khan's personal liberty, the same must be disposed of expeditiously, the top court had ordered. Subsequently, the Allahabad High Court promptly took up the case and ordered Khan's release. The High Court found that prima facie, Dr. Khan's speech does not disclose any effort to promote hatred or violence. It also nowhere threatens peace and tranquility of the city of Aligarh. The address gives a call for national integrity and unity among the citizens. The speech also deprecates any kind of violence. While questioning the credibility of the witness in the case, the Karkarduma court granted bail to Shah Alam, the younger brother of former Aam Aadmi Party councillor and prime accused in the any Delhi riots case, Tahir Hussain, in one of the cases related to the riots. The additional sessions judge Vinod Yadav disposed of the bail plea of Shah Alam while questioning the beat constables as to why they waited till 6th March, when they had categorically seen and identified the applicant indulging in riots on the date of incident, that is 2nd February. Notably, the court also remarked, he cannot be made to incarcerate in jail for infinity merely on account of fact that he is younger brother of the principal accused Tahir Hussain, or that other persons who were part of the riotous mob have to be identified and arrested in the matter. In this backdrop, the court said, in this case, only one witness has been added. I have been taken through this complaint, and upon a perusal of the endorsement made on the complaint, it appears that the name of this witness has been kept deliberately in this case, as there was no other independent witness. Further, considering the facts and circumstances of the case in totality, applicant Shah Alam was admitted to bail in the matter on his furnishing a personal bond of the sum of Rs 20,000 only. Kerala High Court dismisses former Kerala PWD Minister Ibrahim Kunju's bail plea in Paliruvotham flyover graft case. The court has, however, granted Kunju liberty to move a fresh bail application once he is discharged from hospital, where he is presently being treated for various ailments.
The Kerala High Court has dismissed former PWD Minister Ibrahim Kunju's bail plea in the Palarivattam flyover corruption case while granting him liberty to move a fresh bail application once he is discharged from hospital, where he is presently being treated for various illnesses. A single judge bench of Justice P.V. Kunhi Krishnan issued the order. On Friday, Ibrahim Kunju's counsel, senior advocate B. Raman Pillai, argued that the minister had no role in any graft during the project, since he was actively involved in various other programs as a minister. All the necessary documents were vetted by secretaries, after which the minister affixed his signature to them. It was submitted. There were no discrepancies pointed out to him at any stage. Senior advocate Raman Pillai averred. The state attorney, on the other hand, asserted that the department needed to question him further on the question of bribe and the payment of advance. He conceded that while paying advance on projects was a practice for other works contracts, it was barred by law for PWD work. Agreeing that the former minister could remain in hospital as against prison whilst investigation was going on, he urged the court not to release the minister on bail. After hearing Ibrahim Kunju's counsel, the state attorney, Justice Kunhi Krishnan, proceeded to reserve the matter for orders. The Palarivattam flyover, a pet project of the previous United Democratic Front government, ran into trouble after the flyover was found to be unsafe for commute. Shortly thereafter, the project began to be investigated for graft. Investigating authorities have argued that the Palarivattam flyover contract was not handed to the lowest bidder, as was the usual practice. The payment of an advance amount for the project to the contractors has also been assailed. Last month, Ibrahim Kunju, the minister who had been at the helm of the PWD during project's completion, was arrested by the Vigilance Department, citing his probable involvement in corruption. The department claimed that the minister was not cooperating with investigation, while alleging that the minister had taken a bribe for the project. Bureau Report.
Allahabad High Court has showed concern over the steps taken to curb coronavirus by administration of 4 Uttar Pradesh cities. Court has said much is yet to be done by police to effectively install norms of social distancing. The court has directed them to file the affidavit with better information on the next date.
The Allahabad High Court has expressed dissatisfaction over the stopgap measures in the wake of rising cases of coronavirus infections in the 4 major cities of Uttar Pradesh, capital Lucknow, Ghaziabad, Gautam Budh Nagar and Noida and Meerut. Court has said that although the police are making a lot of efforts, the infection is increasing, which suggests that much more remains to be done. After looking at the affidavit filed by the police and administrative heads of these districts, the court said that complete information has not been given to them. The court has directed them to file the affidavit with better information on the next day. Court has also said on every road 2 constables should be deployed every 2 kilometers. We should make people wear masks mandatorily. For the next hearing, the court has asked for the list of names of policemen who have been thus assigned. Additional Advocate General Manish Goel said that the coronavirus testing is being increased every day. The bench said that due to lack of proper tracking of infected, there is no success in preventing infection. After hearing the affidavit submitted by Lucknow District Magistrate, the Division Bench of Justices Siddharth Verma and Justice Ajit Kumar said that it's worrying to find more than 300 infected every day. Advocate Commissioner said that despite the order of the court, the food items are still being sold loose and eaten in open. The court said that it should be ensured that the food items are sold in a closed packet. The bench has praised the efforts being made by Prayagraj police. Due to strict adherence of the rule of wearing masks, there has been a significant decrease in the number of infected people in Prayagraj. The High Court was told that many schools and colleges have been open since December 7th, but there is no system to ensure teachers and students follow the COVID-19 guidelines. The court said that there was every possibility of violation of the guidelines by young children. Therefore, regular monitoring and sanitization of private and government schools should be done without discrimination. Bureau Report.
That's all for Courts Roundup today. Keep watching APN.
India Legal presents Courts Roundup.